Morning, everybody.
Good morning, Your Honor.
Morning.
Good morning, Your Honor.
Good morning.
Oh,
Okay,
scare you off my face there.
watching these tiles light up. It's good. We'll once again do some introductions in just a moment.
Okay,
Soon
Your
as we get everybody on. Mr. Lane, you can either say it out loud or you can send it to me in the chat. In fact, if you don't mind sending it to me in the chat, your telephone number, please.
Right away, Your Honor.
Thank you. So I've got Mr. Gulch. Where's Mr. McDougal?
Your Honor, he's going to be here.
Yes,
Okay.
Your Honor. I'll check
Spoke
with him right
yesterday.
now.
Okay. I have a number of different my clocks all say different things here in the courtroom. Okay, got Mr. Gulch. I got Mr. Webb. Do we have Mr. Brent Wilson? Is he still in the case? Brent Wilson?
Your Honor, he is still in the case. I'll check if he's appearing today. I work with Mr. Wilson at
Okay.
Fisher Phillips, so I'll check.
So otherwise you're for Equity Prime, Mr. Holdsworth?
Yes, along with Daniel Watkins as well, who's
Right.
and Mark Thompson.
I got him checked in. So we're waiting on Mr. McDougal and here he comes. And then we're waiting possibly on Mr. Wilson. Hey, Mr. McDougal, welcome.
Good morning, Judge. How are you?
And pardon me, Ms. Buckler, who are you representing?
Yes, good morning, Your Honor. I represent with Mr. McDougal, the Green defendants.
Oh, God, I already had you marked in. Okay, I think I've got everybody. There's some other people, tiles that are not lit up, and if you feel you need to introduce them, I'm going to certainly give you an opportunity to do that. But Mr. Lane, you ready?
Judge, I can't access the chat. Can I just quote the numbers to you right now?
Oh, sure. Yes.
The firm contact number is 678
Okay.
770
Okay.
3151.
All right. That's
that's-
all I need.
Very good.
I'll find you. I need you. I'll find you. All right. Then good morning, everyone. This is Equity Prime Mortgage LLC versus Melissa Rolfe, Green for Congress Incorporated, and Marjorie T. Green. And this is 2020 CV 339285. Just a couple of preliminary issues. I am in the courtroom down at the courthouse. And however, we do not have a deputy in the courtroom, and therefore the courtroom itself is locked. The solution for that, which we're happy about, is I have placed this hearing on the court's YouTube live stream channel. And if you will look at the top of your machine, I'm fairly clear should have something, but you'll see an icon that says YouTube. And that means that we are, for this period, the period only of the hearing itself, we are fulfilling an obligation which we take very seriously, which is to make certain that the public's business remains open and accessible to it. And similarly, just like anyone could walk in the back of the courtroom, they can turn on the court's YouTube channel. When we have finished, I will take the video down. So it will not be out there forever. It does not substitute as a transcript. But once again, we're serious about it and we're complying with it. So with that, if anyone feels the need to introduce anyone who is not lit up, I think we're going to start wrestling the topic of what we're hearing today.
Daniel
I'll go-
Watkins for plaintiff equity prime mortgage. I'll ask for the court's indulgence today. I'm a little under the weather, but I'm here to fight and here to answer whatever questions the court may have. I'd also like to introduce Seth Kreiner, who his box is not lit up, but he's outside counsel for equity prime mortgage. And just for clarity of record, you have Daniel Watkins, Tim Holdsworth, Brent Wilson, and Seth Kreiner representing plaintiff in this case.
Great, thanks. Defendants, do y'all want to take advantage of the same?
Sure, Your Honor. So it's Harry McDougall for the Green defendants, along with Ms. Buckler. And with us as well is David Rusnak, who will not only be listening, but not speaking.
Okay. Welcome, welcome everybody. And Mr. Goldenshire, are you just by yourself?
Your Honor, thank you. I'm solo practice, so legal wise, yes, but my client is here. You'll see Marty Rolfe, that name out there. And so the Rolfes are here and we'll just be listening today, Your Honor.
Okay, great.
And Judge, my apologies. I left out my colleague. This is Daniel Watkins speaking for Equity Prime. I left out my colleague, Mark Thompson, who's also on the line.
Okay. All right. I think we are sufficiently lawyered. Everybody, please remember there's only one judge. All right. Now here, I'm going to go first and I'm going to tell you where I think we are. And then you can certainly, and then you can correct the record. I believe our last hearing was May 30th, after our latest remand. And during that hearing, which was a great hearing and spirited as always, the issue of the Supreme Court's opinion, and please correct me on this, but I'm going to go with Ascui. Ascui? What do y'all say?
Oscue.
I've been
Ascui.
saying Oscaway because I can make a joke out of this away, that away, or Oscaway.
I like it. Okay. The issue came up during our last hearing of the Oscaway opinion and felt that it had sufficient impact on the facts and law of this case to step back and take a good look at it, due not only to its relative recent publication and also, I'll be honest, its length. So we did that, and while we were waiting, and I kind of thought we might just do that on briefs, but while we were waiting, 2 amended answers were filed and an objection to at least one or both of those answers. So I'm to be guided. Obviously, we can't all talk at once, but I'm to be guided as to what you want. I would think that it would make sense to take up first the issue of the amended answers. But if y'all have talked, if you have an order that you want to go in, I'm completely willing to honor that. So we'll do this the old-fashioned way. Plaintiffs, Mr. Wilson, Holdsworth, or Watkins, what do you think we're here for today?
Thank you, Judge. So if the court would like to spend time talking about the amended answer, then the appropriate procedure to do that is to notice a hearing on that issue. We do not have notice that that's being discussed today, despite the filing that was made after the last court hearing. Today's court hearing should be based on the court's request that the parties update the court and help educate the court on the impact that Oscue has on the present litigation. If you would like argument related to the putative amendment, then that should be held separately and noticed properly, not just so plaintiff has appropriate time and notice to prepare for such an argument, but so that the public is also aware that such argument is taking place. And we don't yet have that.
Okay, I've got my feelings on that issue, but who wants to go first, Mr. Goldenshoe or Mr. McDougall, on responding to that?
So, Mr. McDougall here, Your Honor, I'd like to respond to that. The question of whether the Green defendants are entitled to assert that the plaintiff is a limited purpose public figure was addressed at length in the plaintiff's brief, post-hearing brief filed July 15th, 2 months ago. They introduced the question of the objection to whether we were allowed to assert that defense 2 months ago. And so for them to say they're not prepared to argue an argument they made in their brief, that doesn't make any sense to me. Obviously, we'll comply with whatever direction the court gives us, but the issue is important because it goes to what legal standard could be applied, which is what the Oskaway case is about. And that question turns in large part on whether the plaintiff is a limited purpose public figure. So I think if we have an argument with that does not address the public figure issue, then we are wasting time.
Really wasting time?
Y'all give me 1 second, and we'll keep all these comments. Okay, hang on. Okay, our amended notice of hearing, which was entered on August 12th, 2025, simply says we will have a hearing. Does that mean that it is unlimited? I don't necessarily take that position, but please bear in mind that I have 2 hats as the sitting judge on this case. One is to get it right, finally. And the second is docket management. I mean, this is we don't even number cases like this anymore. We've changed our whole numbering system since the year 2020. We are hearing everything today because I don't see how we cannot. There's no use having a hearing unless we can get to what Oskaway talks about. So we're hearing everything. You
And
can
Judge,
put
to
that in. Whoa, I get to finish. We're hearing everything. You can put that into the basket for the next court to complain about. With that, you want to go on, does the plaintiff want,
we'll begin, Your Honor.
okay. On
And-
what? The objection to the amendments?
I'm sorry?
The objection to the amendments?
I think it may be better so I want to clarify my position and then hopefully begin argument, but we're prepared to talk about why defendant's stipulation with respect to EPM being a private figure is binding. What I was simply saying was to the extent that we're litigating whether the amendment should be stricken or withdrawn, et cetera, that should be handled separately under a separate motion. I wasn't trying to say that we shouldn't spend time talking about those issues, but our objection has been filed, and I think duly noted, their amendment has been filed, and there is not a motion to strike that amendment, et cetera. So I was simply saying, based on due process and notice requirements, I don't understand this hearing to be about litigating whether they're permitted to amend their answer, but rather understanding the legal contours of where we are based on Oskaway.
Okay, well then you want to go on?
Yes, Your Honor. And
Okay.
to simplify things, I have just a couple of slides to share. I'm not the most technologically advanced, but I think we can make this work. Can you see my
Yeah.
slides there?
I can, thank you.
Okay, give me 1 second. Okay, thank you for your patience. We've been litigating this case now for more than 5 years. When this case was filed, I worked at a different law firm. I was a bachelor, and in the preceding 5 years, I've not only met my wife, my better half, but also welcomed the son into this world.
Oh, congratulations.
Thank you. And while I'm thankful for all of those developments, what it reflects is just the amount of time, attention, energy, and effort that plaintiff has put in this case. We've been on appeal and back twice, and the very purpose of the anti-SLAPP statute is to stop frivolous complaints from proceeding. But here, based on the tortured procedural posture and the history that we're all familiar with, the anti-SLAPP statute has actually been used to stymie meritorious litigation, and it's forced Equity Prime Mortgage to spend hundreds of thousands of dollars and many, many years of its time in order to proceed past the earliest stages of this litigation. Given all of the preceding orders and I believe the court's familiarity with the case, I think that the best course of action is for us to really identify the two key legal issues that we're wrestling with today. The first issue is that defendants stipulated that EPM is a private figure. Now, what does that mean? That means that the fault standard is negligence. The Supreme Court explained this in Gertz, and we have precedent from the Georgia Supreme Court explaining the same fact. Now, the reason that defendants have attempted to amend their answer is because they're no longer happy with their stipulation regarding EPM being a private figure. I don't believe that counsel for defendants would have stipulated to something that wasn't true. And I don't believe that counsel for defendants would have stipulated to something that didn't advance their client's legal position. But regardless of the reasons for the stipulation was made in January of 2023. And up until the most recent brief filed by defendants, that represented the four corners of the case with respect to EPM's status and the attendant fault standard. So that's the first issue. The second issue is Oskoway. After remand, the Supreme Court of Georgia issued a lengthy opinion, as the court just referenced, in Oskoway, explaining that a plaintiff can overcome a conditional privilege by making a showing of private malice. So there's quite a few distractions, and I'll stop sharing now, but there are quite a... Would you like to see it again, Your Honor?
Yeah, put it back up. Just let me get one thing.
If you want to copy the language into your order, we're happy to leave it up.
No, you can take it down now. I'm good. Thanks.
Okay. I'll leave it up a little while longer. So these are the primary issues in the case. I think that there are a lot of other distractions and low-hanging fruit that may come into play later, but just as a reminder for the court, what we're here to decide and understand is in the context of ruling on an anti-SLAPP motion is whether the plaintiff's case has minimal merit. It's whether the plaintiff's case has minimal merit. On remand, the Court of Appeals identified the reversible error that this court committed in granting the defendant's anti-SLAPP motion. On remand, the Court of Appeals directed the trial court to allow Equity Prime Mortgage to engage in discovery on the issue of malice. The problem is the issue of malice was changed by Oskoway. So instead of the actual malice standard that the Court of Appeals believed applied to overcome the conditional privilege, we're dealing instead with private malice. And the language from the Court of Appeals explaining that EPM has already made a prima facie case of actual malice should simplify the issue. Satisfying the private malice standard is not a heavy lift, and I have a few more slides on that issue that I can share. What constitutes private malice? These are cases cited in our brief. Describing a plaintiff's restaurant as not a very good place to eat and calling a plaintiff a dope addict who was on drugs satisfies a showing of of private malice. The courts look to the nature of the statements to make inferences about whether ill will is present. I want to make sure I'm no longer sharing. Thank you. And so part of the reason that we're having such a food fight and wrestling match regarding the stipulation is because it's important to defendants that they're not required to it's important to the defendants that EPM is required to satisfy that higher threshold. And luckily, the Supreme Court's decision in Oskaway and the United States Supreme Court's court decision on these very same issues create a roadmap for us to proceed. So instead of moving forward with the malice discovery ordered on remand by the Court of Appeals, Equity Prime instead asks that the court deny defendants' anti-SLAPP motion and 5 years later finally allow us to proceed with discovery so that we can finally litigate and prosecute our claims, as is our right under Georgia law. I'm happy to answer any clarifying questions that the court may have, but we tried to do our best to outline these issues in our brief, and we would earnestly ask the court to follow the law here and not be swept into additional error by disregarding the Supreme Court's mandate in Oskaway and the other guidance that we have with respect to a private figure's burden here, which would obviously be negligence instead of actual malice. But I'm happy to answer any questions that the court may have.
Okay, let me do something totally stupid, Mr. Watkins, and tell you what I heard so that you can correct me. All right, you want to freeze defendants at their position that Equity Prime Mortgage was a private figure. Their stipulation, so freeze it that EPM is a private figure which carries with it the lower burden of proof to avoid anti-SLAPP by EPM. Because Oskaway suggests or says that if it's a limited purpose, whatever, private figure, you got to go back to actual malice.
No, Your Honor.
Okay, good. Help.
So I think conceptually it's important to separate two things.
I
The first is fault as an element to defamation. That's the first conceptual framework. The second conceptual framework is, what does it take to overcome a privilege? So let's start with the first conceptual framework of fault. Under Georgia law, if the plaintiff is a private figure, the applicable standard of fault is negligence.
Okay.
And I was afraid that you would ask that question, so I prepared a slide that would be useful. We don't have to invent any laws here. The Supreme Court of Georgia has already explained the law. If plaintiff is a private figure, then a negligence standard applies. It's very
Okay.
simple. So that's the issue of fault. So if you agree with us that the stipulation is binding, then negligence is the fault standard that controls. And we can walk away from that. The second conceptual issue is the conditional privilege. And this is where Oskaway comes in. There was confusion in the Court of Appeals as to whether actual malice, which is a reckless disregard for the truth, whether actual malice, a very high standard, was required to overcome a conditional privilege. And let me say that more simply. When the defendant satisfies their showing that the relevant statement is conditionally privileged, before Oskaway, there wasn't unity at the Court of Appeals level in terms of what a plaintiff had to show to overcome that privilege. Oskaway comes in and says, hey, it's not actual malice. It's private malice, which is a much lower standard. It's easy to satisfy. It's ill will towards the plaintiff. Okay? So those are the two elements where scienter, where the defendant's state of mind comes into play. But we have to be disciplined. We must be disciplined in order to get this legal question correct. And that is, number one, what level of fault is required? Is it negligence or is it actual malice? If EPM is a private figure, as a matter of black letter law, the fault standard is negligence, period. Second question, what must EPM show to overcome the conditional privilege? Oskaway answered that question. We must only show private malice, which is a considerably lower standard than actual malice, but private malice, which simply means ill will towards the plaintiff. Those are the two questions. Where it gets complicated and confusing is sometimes courts just say malice instead of specifying actual malice and special malice, but those are the very clear and distinct legal issues that we are navigating. Now, defendants invite you to make reversible error by saying, wait, well, this is a matter of public concern, so you always have to show malice because presumed damages come into play and punitive damages, et cetera, right? But in Gertz, the United States Supreme Court explained, in the context of a private figure plaintiff, they need only satisfy negligence as a fault standard in a defamation case. It's a separate legal question what we have to prove in order to recover punitive damages or presumed damages. That's a separate legal question that we don't have to wrestle with today, because the question is whether our case has minimal merit. And since we're seeking actual damages, we don't need to delve into punitive damages or presumed damages. And by the way, we have another convenient stipulation by the defendants. They've stipulated the damages, so we don't even have to wrestle with that. But those are the legal issues that we're dealing with, and I'm hopeful that we won't be whipsawed and that the foundation of the case, that the law of the case with respect to defendant stipulation on our status as a private figure will not be reversed, because it goes against so many key and core principles that allow us to proceed in this case in an orderly fashion. But those are the two legal issues that we're dealing with. What does it take to overcome a conditional privilege, and what level of fault on a defamation claim must EPM prove to prevail?
Okay. Mr. McDougall, are you up next?
I hope so.
Okay, go.
All right. So first of all, I'd just like to say good morning to all the other lawyers on this Zoom call. Secondly, there are some things that Mr. Watkins has said that I agree with, and there are quite a few that I do not agree with. I do agree that Oskaway changed the law from what it was before. But considering why we're here again today, it was for the court and the parties to get smart about Oskaway and apply it correctly. And so what I would like to share my screen briefly to show what I think is the logic tree that we're dealing with under Oskaway. So with the court's permission.
Yes, of course.
Thank you. Okay, so are y'all seeing that?
I am.
See it.
Okay, great. So the Oskaway opinion in footnote number 19, which is on page 22, says, because the issues of whether a plaintiff in a defamation case is a public or private figure, and whether he seeks presumed or punitive damages related to a defamatory statement about a matter of public concern, determine whether a court should apply federal constitutional law or state law.
Harry, we lost your audio.
I can hear him. Y'all
I
can't.
can hear. I can hear.
I can hear him.
Okay, David, are you able to hear me now?
I'm now able to hear you. Thank you.
Thank you. Thank you for letting me know. We emphasize that Georgia courts generally should engage in that inquiry as a threshold matter in defamation cases. So there are three factors there for deciding what legal standard applies. Is there do the statements relate to a matter of public concern? That's already been established in this case. Secondly, is the plaintiff a public figure or a private figure? That's what the fight is about, reasserting that defense. And then third, whether they're seeking presumed or punitive damages. So this slide just shows the sort of decision tree that you follow for this. Is first tier public or private figure. If they're a public figure, the constitutional actual malice standard applies. If they're a private figure, you have to answer a couple more questions. Is the statement about a matter of public concern? If the answer to that is yes, are they seeking presumed or punitive damages? If they are, then the actual malice standard applies. If they're a private figure seeking actual damages, only actual damages, then the state law private malice standard applies. So that's the sort of framework, and that takes us immediately into whether we are allowed legally to assert at this point that the plaintiff is a limited purpose public figure. And so the argument is that we have made a stipulation on that, and we're bound by it either as a stipulation, admission in judicio, or under the judicial estoppel doctrine. So let's take first the admissions in judicio doctrine. Excuse me. Admissions in judicio apply to facts in a particular case. They do not apply to questions of law for the court. Whether the plaintiff is a public figure is a question of law for the court. Mathis v. Cannon says that explicitly, page 22 and 23, quote, whether a person is a public figure is a question of law. In the last opinion by the Court of Appeals, what I call EPM 2, they had another footnote number 5. And that's on page 449 of the Georgia Appeals Report. And this is after reviewing the procedural history of the case and observing or noting that we had withdrawn the public figure defense. The court said the following: for reasons that are not immediately apparent, neither the trial court nor EPM addressed whether Green, as a litigant, was authorized to unilaterally dictate whether the company could be considered a limited public figure for purposes of this action or for determining the applicability of OCGA section 911.1B2. That line is immediately followed by the quotation from Mathis v. Cannon that whether they are a public figure is a question of law for the court. So what is the Court of Appeals telling us with that footnote? That we as a litigant are not authorized to unilaterally dictate the outcome of a question of law for the court to decide. That makes sense when looked at from multiple perspectives. First of all, in the ACLU versus Zay case, if I'm saying Mr. Zay's name correctly, The court in a defamation public figure First Amendment case is obliged to make an independent examination of the whole record to ensure that the judgment does not constitute a forbidden intrusion on the field of free expression. That's at page, the Zay case is 312 Georgia 647, and that lands at page 653. They cite a wealth of authority from the U.S. Supreme Court for that proposition that in evaluating the question, the court is to make an independent evaluation of the entire record. So it's a question of law for the court, not a question of fact. Stipulations, admissions in judicio relate to questions of fact, not questions of law. If we move to the concept of judicial estoppel, the Supreme Court of the United States clarified the federal law on that doctrine in a case called New Hampshire versus Maine in 2001. And the Georgia Supreme Court adopted that the following year in a case called IBF, Participating Income Fund versus Dillard Weinkauf. That's 275 Georgia 765. Both of those cases describe it as an equitable doctrine that's committed to the discretion of the trial court. They say that because it's an equitable doctrine, there's no rigid set of essential elements like you have for some rules of law. Instead, it's to protect the integrity of the judicial system from being gamed and made a plaything, prevent perversion of the judicial process. That's the objective of the doctrine. So the classic concerns of equity are paramount. Is it fair? Has someone relied to their detriment? Has someone gained an unfair advantage? Those are the kinds of things that dominate the analysis in judicial estoppel cases. But despite the lack of fixed essential elements, they do identify typical factors. One is the positions must be inconsistent. Second, and this is a quote from the Supreme Court, U.S. Supreme Court, courts regularly inquire whether the party has succeeded in persuading a court to accept that party's earlier position, so that judicial acceptance of an inconsistent position in a later proceeding would create a perception that either the first or the second court was misled. Absent success in a prior proceeding, a party's later inconsistent position introduces no risk of inconsistent court determinations. And the third factor is, would the party asserting the inconsistent position derive an unfair advantage? So how do we map those factors onto this case? The second and third factors are not present here because we did not have success in the position that we took. Absent success, there's no risk of inconsistent court determinations. There's no advantage to us and no prejudice to them. Now, some of the cases would give the impression that the doctrine applies across more than one case. You take a position in one case, you prevail on it. You take an opposite position in a later case. That's how most of the cases present. But, you know, in candor, I have to say not all cases present that way. There's a Georgia Supreme Court case called Smith v. State, where the doctrine was applied within the same case. A party changed their position on appeal, and it was held that they were not allowed to do that. There are many pre-existing doctrines of appellate practice that would preclude you from doing that. But in that particular case, they decided it that way under the heading of judicial estoppel. No cases have been cited, to your honor, that hold that where the advantage was reversed on appeal, that the party is precluded by judicial estoppel. The advantage that was gained was reversed and taken away by the Court of Appeals. They haven't cited you a case to that effect, and I have not been able to find a case to that effect. There's some statutes that are relevant to the analysis. First, I would cite to the court the rule, which is codified in 23-1-6, that equity follows the law and is not antagonistic to the law. There's a statute in the evidence code on estoppels, and that's 24-14-26. Among other things, it says estoppels are disfavored. And it lists 8 separate categories of estoppels, but the one I would like to discuss or highlight is the catch-all category at the end of the statute. Estoppels also include all similar cases where it would be more unjust and productive of evil to hear the truth than to forbear investigation. And that brings us back around to the concept, the core equity concepts. What is fair and just under the circumstances? In this particular case, it would be inequitable to preclude assertion of the public figure defense. And that is because the law on which our position was premised at the time was overruled by Oskoway. We argued when we withdrew the public figure defense that we didn't need it because the fact that the speech related to a matter of public concern, or the determination that it related to a matter of public concern, automatically put us into the actual malice standard. That was based on Neff versus McGee. And that's explicit in our briefing in this case up until our last post-hearing brief when we were dealing with Oskoway. Oskoway overruled Neff versus McGee on that very point. And so the ground under our feet has changed, apart from the fact that the last opinion reversed and erased any advantage that might have been gained. And we explained that in our filings. We made a filing on January 13th of 23 that counsel has cited. And we said there, that argument is no longer necessary to establish referring to the public figure defense, no longer necessary to establish a conditional privilege because a conditional privilege has otherwise been established as a matter of law by the Court of Appeals holding that her speech related to a matter of public concern. And since Rep. Green no longer contends and no longer needs to contend that EPM is a limited purpose public figure. That's pages 2 and 3 of that filing. So Neff versus McGee was one of 18 cases overruled by Neff versus McGee. So we took it for granted, based on Neff versus McGee, that the actual malice standard applied. And you can see that throughout our briefing. It would be unfair to bind us to that when it was based on case law that has since been overruled. In addition, our argument about the scope of permissible discovery under the anti-SLAPP statute was reversed in EPM 2. We made an argument about how the statute works. Your Honor agreed with that argument. The Court of Appeals did not. They reversed it. So on two separate grounds. Now you say, well, you read the statute wrong. That's your problem. Okay, I mean, maybe. But we didn't read Neff versus McGee wrong. We read it correctly, but the Supreme Court said it read the law of defamation incorrectly. So after Oskaway, you need more than just speech about a matter of public concern in order to get into the actual malice standard. You need the public figure element. And if you're a private figure, you need them to be seeking punitive or presumed damages. A couple of other statutes that are relevant under the concept that equity follows the law and is not antagonistic to the law is we're in a pretrial posture. We are at the preliminary motion practice under the anti-SLAPP statute. There's been no discovery. There's been no pretrial order. There's been no trial. There's been no judgment. Rule 15, which is a statute, allows us to freely amend our pleadings at this point in the case. Rule 8E2, which is also a statute, allows us to assert as many separate claims or defenses as we have, regardless of consistency and regardless of whether based on legal or equitable grounds or both. So summing up, Your Honor, it's a legal question for the court, and we cannot take that legal determination away from the court unilaterally. That's what footnote 5 of EPM says. Second, the court has an independent duty to decide the public figure question for itself. Third, we did not succeed in the argument. Fourth, the position that we took was based on the law as it stood at the time. That was overruled in Neff versus McGee. Overruled in Oskaway. Fifth is based on an interpretation of the statute that the Court of Appeals rejected. Sixth, the statement was made in a pleading, not in a pleading, but in a brief. There is law that to be bound, the statement has to be made in a pleading. The case of Anderson versus Kay, 371 Appeals 626, a party in an interrogatory response withdrew a statute of limitations defense. The Court of Appeals held they were not bound by that because the interrogatory response was not a pleading. And lastly, under all the surrounding circumstances, we think it would be unfair to preclude us from asserting this defense. And that is based on the wealth of material that we have provided the court, substantiating the idea that the plaintiff is a limited purpose public figure as a result of having inserted itself into the public debate about the matters of public concern to which Representative Green's speech related. Now, this is all kind of argument that's new to the court. This was not in our brief. If the court would receive it, we would offer to file a short brief dealing with the estoppel, admissions in judicio considerations, and to do that very promptly. Sometime next week, we could do that by the middle of next week. Give Mr. Watkins as much time as he wants, but there is a semi-intricate step through that argument, and it might be helpful to the court to have that in writing as opposed to me talking on a camera. But I'll leave that to however the court wants to proceed on that. If we then move to back kind of around the mulberry bush and come back to the public figure issue. EPM has not responded to the substance of the public figure evidence or argument. And we had, we spent several pages collecting statements made by EPM on these issues that were consuming the country in the summer of 2020, June of 2020. The test for determining whether they're a public figure or a limited purpose public figure is in Mathis v. Cannon, and it's three-part test. One, the court must isolate the public controversy, that is to say, define what the controversy was. Second,
Before we get into this, Mr. McDougall, and I'm also, of course, going to go back and ask Mr. Watkins the same thing, but help me remember where we are. So I think before, as you call it, EPM 2, I think that there was an order entered by the court, which was affirmed in a little part and reversed in a big part, having to do, among other things, with the issue of discovery.
right.
What are we arguing now? Aren't we kind of going back a couple of years and arguing that issue, finishing that up as
Yes.
instructed by the court by the EPM 2?
Yeah, in a word, yes. I mean, I can elaborate on that, but in a word, yes.
Okay. You keep going.
All right, so kind of just returning to that or expanding on that just a little bit, Your Honor. The Court of Appeals in EPM 2 said before allowing EPM to carry out discovery on actual malice, and this is pre-Oskaway, right? Before allowing them to discovery, the court had to make a determination about whether there had made a sufficient showing on the third and fourth elements of the claim, which are fault and damages. And we have conceded for this stage of the case, for the motion to dismiss stage of the case, that they've made a sufficient showing on the damages question. So we're back to fault, and we're back to what's the standard for overcoming the conditional privilege. And those questions under Oskaway turn on the three things. Was the speech on a matter of public concern? We know the answer to that is yes. Are they a public figure? We're fighting about that now. And three, if they're a private figure, are they seeking presumed and punitive damages? So I was intending to next walk through the public figure analysis, and then the if they're a private figure, what rule do we apply? So the factors in Mathis v. Cannon for deciding whether they're a public figure, which we have to do under Oskaway, isolate the public controversy. 2, examine the plaintiff's involvement in the controversy. 3, determine whether the alleged defamation was germane to the plaintiff's participation in the controversy. So the controversy, factor 1, was the uproar that was consuming the whole country in June of 2020 about Black Lives Matter and George Floyd, Rayshard Brooks, excessive force against Black suspects, and whether police were indiscriminately killing Blacks, whether the police should be defunded, and on and on. There were riots all over the United States, including in Atlanta. That segued in the killing of Rayshard Brooks into the termination by the Atlanta Police Department of Garrett Rolfe, who's defendant Melissa Rolfe's stepson. And then that was followed by the termination of Ms. Rolfe. So all these things are bound up together. Plaintiff's involvement. We've cited to the court social media postings by the plaintiff EPM and its CEO, Mr. Perez, that show that they injected themselves into the public debate about these controversies. EPM's active on social media, and in the relevant time frame posted numerous comments about the police, about the racial and police controversies that were tearing up the country. They promoted and adopted slogans of the movement that were circulating at the time in their social media postings. One of their particular posts on Instagram included multiple hashtags that were venues, forums for expression of these ideas. And it urged readers to educate themselves. Educate yourself by clicking on these hashtags. One was Blackout Tuesday. The show must be paused. Justice for Breonna Taylor. Justice for George Floyd. Justice for Ahmaud Arbery. They associated themselves and their brand and their slogan, empowering people more, with all of that. If you accept their invitation to click on those hashtags, you will be immediately subjected to a torrent of vitriolic hostility towards law enforcement and vitriolic and extreme racial hostility towards the police. EPM directly addressed the Black Lives Matter controversy as it existed even before the death of Rayshard Brooks in a video they posted on YouTube on June 8th of 2020. It was called A Message from Eddie Perez at Equity Prime Mortgage about police issues facing our country. It went on for 17 minutes. And Mr. Perez expounding on his views and unique insights on these topics, including Black Lives Matter, the death of George Floyd, support for law enforcement, and so on. We cited that video and linked to it in our original motion to dismiss under the anti-SLAPP statute. Between the time of filing that motion and the time of our reply, that video was deleted. The third factor, is the speech germane to the controversy. That's talking about is Ms. Green's speech germane to the controversy. Well, Mr. Perez and Representative Green were talking about the same topics. Black Lives Matter, defunding the police, support for law enforcement, relationship between law enforcement and the Black community, and so on. And the controversy over the Rayshard Brooks shooting that then became a controversy over Ms. Rolfe and her termination, those are all part of the same overall controversy as it unfolded in real time back in 2020. So we contend that based on all of that, that there's ample grounds for the court to find as a question of law that they were a limited purpose public figure. So if that's the case, what is the legal consequence of that? The legal consequence is that the actual malice standard applies both to overcoming the conditional privilege and to the standard of fault. And Mathis v. Cannon says that. So Mathis v. Cannon was one of the issues in that case was the plaintiff a limited purpose public figure. They announced that three-part test. They walked through the evidence. They concluded he was a limited purpose public figure. And they said, because of that, he was a limited purpose public figure. and said this conclusion means that he must meet the standard of fault established in the New York Times v. Sullivan case. Under that standard, Cannon must show by clear and convincing evidence that Mathis published false and defamatory statements knowing that they were false or acting in reckless disregard of truth or falsity. So the whole framing of plaintiff's argument is that under no circumstances are we in the actual malice box, that we're not there because we're not allowed to make the public purpose, a public figure argument. And they put all their eggs on that. If we're allowed to make the argument, they haven't responded to it on the merits. They haven't said a word about why they're not a limited purpose public figure, other than we don't get to make the argument. That's the entirety of their position on that. Now, the last threshold question is, what kind of damages are they seeking? And Mr. Watkins suggested we put that off. So let's just sort of clarify where we find ourselves on that, what the court's got to consider and look at. So the rule in Oskaway, which is derived from the U.S. Supreme Court cases starting with Gertz v. Welch, is that even a private figure plaintiff who claims injury from speech on a matter of public concern and who is seeking presumed or punitive damages must meet the actual malice standard. If they are seeking only actual damages, then the state law private malice standard of fault applies. So it is useful to know whether the plaintiff is seeking presumed or punitive damages. The answer is they are. Their amended complaint explicitly pleads for presumed and punitive damages against all defendants. That's in paragraphs 54, 64, and 65. They have a whole heading before paragraph, I think, 64. Defendant's conduct warrants punitive damages, and defendants is plural. No distinction between any of the defendants. In their brief, most recent brief, on page 6 in note 25, footnote 25, they say they're not seeking presumed or punitive damages against Green for Congress. Well, if that's the case, they should amend their complaint. They don't make any statement one way or the other about not seeking those damages as to Representative Green, as distinct from Green for Congress. So as we sit here, they are seeking those damages. And therefore, to that extent, must meet the actual malice standard. Now that does bring us around to a point that I've made before, and to which I don't believe they have responded and it hadn't been ruled on. But that is that under 51-5-11, that's the retraction statute. And they made a demand for a retraction. And under the retraction statute, the defendant has 7 days within which to comply or not comply. And under the last subsection of that statute, if the defendant proves that the suit was filed before the 7 days run, then the plaintiff is barred from recovery of punitive damages or presumed damages. And in fact, they filed 6 days after their demand. They did not wait the full 7 days. So if, to the extent they are limited, if they're a private figure, the speech is on a matter of public concern, and they're only seeking actual damages, then the private malice standard applies. But that hadn't been ruled on yet. They haven't acknowledged that they're barred from presumed impunitives. They're still seeking them. All right, so where does that leave us? If the court denies our motion altogether,
Which motion is that?
that would be the anti-SLAPP motion to dismiss
Motion
the entire ball of wax that's
Okay.
occupied the last couple of years. If that's denied in its entirety, then we're in regular discovery. If the court finds that the plaintiff is a limited purpose public figure, and included within that would be a determination of whether we are allowed at this point to make that argument, then they have got to show actual malice, or they have a chance of prevailing on actual malice in order to overcome the motion. Now, the Court of Appeals has held pre-Oskaway that they are entitled to carry out discovery on actual malice. So harmonizing our last instruction from the Court of Appeals with Oskaway and assuming that we're entitled to assert the public figure defense, then they have to overcome the actual malice standard. And I think the correct reading of EPM 2 and Oskaway is that they are entitled to limited discovery on actual malice. So those are the two paths that are in front of us, one or the other. And so I think I'm finished. Subject to any questions that the court may have, and if the court would like us to submit a post-argument brief on the entitlement to assert the public figure defense that addresses the admissions in judicio and estoppel arguments.
All right. Thank you. Mr. McDougall, at this time, Mr. Golden, do you have anything you would like to argue on behalf of your defendant?
Your Honor, at this point, it is not affecting my defendant, my client. If we get to discovery, I may or may not have some comments on that once we see if we're going to get there or not, Your Honor. Thank you for asking.
All right. Thank you. Okay. Mr. Watkins.
I'm troubled, Judge. I'm very troubled.
Uh-oh.
We just heard argument on several issues, some of which weren't briefed for you because our belief of the playing field was that we weren't here to talk about private versus public figure. We're here to talk about Oskaway. And Oskaway does nothing. Oskaway does nothing to impact the public figure versus private figure distinction. Period. It does not address that distinction whatsoever. So the reason that we haven't briefed the public figure issue is because it's far outside the scope of what the court has asked us to do. We can point you to cases explaining why posting something on social media doesn't make you a public figure, or being drawn into a controversy that's ginned up by a defendant doesn't make you a public figure. But that's not what we're here to talk about today, Judge. We're here to talk about whether the stipulation the defendants made is binding. And you heard some comments on Anderson versus Kay. That was your case, Judge.
Oh, yeah.
And what I heard during argument was that it was reversed because the stipulation was made in an interrogatory. But that's not what happened in the case. And I invite the court to review that opinion. What was made clear is that the defendant didn't rely on the stipulation to their detriment. It wasn't that it didn't appear in a pleading. Stipulations can be made elsewhere. And here we're pretending as though EPM was not harmed by this stipulation. So let's just be very clear about what actually happened. Absent the stipulation, EPM was statutorily entitled to automatic discovery. That didn't happen. And instead, we had to fight this on appeal for years and years and years and spend hundreds of thousands of dollars litigating the case in the appellate court and not even litigating the issue of public versus private figure because it had been stipulated. And the reason that it was stipulated is because it gave benefit to defendants. Specifically, they were not subject to automatic discovery. And it took that right away from the plaintiff. So that's our detriment, right? And as we cited in our brief, I'll give you the citation. Long v. Arcel, that's an old Fifth Circuit case. The plaintiffs stipulated that they were public figures, but then they decided to try to turn that around when it no longer fit their strategery. And I'm sorry?
No, I got the reference and I laughed.
Thank you. Sorry. I'm a little heated. It's been 5 years, Your Honor. I apologize. But the court explained just because you misread the law or because the law changed or your strategy didn't go the way you wanted, you can't just turn around and reverse positions. Stipulations matter. They're not taken lightly. And when the court and the opposing party relies on those stipulations, you can't just wriggle out of them when it suits you. And that's what we're dealing with right now, Your Honor. The other really important point on this stipulation is courts in Georgia and the 11th Circuit and in other states have made clear that it is perfectly ordinary for parties to stipulate the issue of private versus public figure. We see that in DeBerry, 170, Georgia App at 104. We see it in Straw v. Chase, Hunt v. Liberty Lobby, Lee versus City of Rochester. That's footnote 42 in our latest brief, Your Honor. All the cases are there. And so this notion that defendants were not able to stipulate on this issue is just a complete farce. But excuse me for jumping around here. One other point is the passage of time alone isn't the only prejudice, right? There are things that come along with that. Memories fade, documents disappear, and the depositions that we'll be taking in 2025 are not going to be anything like the depositions that would have taken place in 2020 because of this extensive delay that's taken place. So this is not an issue of a mulligan, no harm, no foul. There actually is real prejudice beyond losing out on the statutory protection and statutory rights to automatic discovery, beyond having to appeal and fight like hell in order to vindicate our rights, and beyond everything else that's changed the landscape of the case, what we argued when, and why we're still having this argument here in September of 2025. Those are all
Let me ask you a question, Mr. Watkins, and I apologize for interrupting, but okay, so let's say that I take the position that a deal's a deal, and that you said this quacked like a duck and it swam around like a duck, and therefore you stipulated that it was a duck. And discovery shows, as a matter of fact, and I realize Mr. McDougall wants the court to make a decision as a matter of law because of his claimed obviousness, but suppose discovery shows that this isn't a duck. I mean, again, I'm trying to figure out what I'm deciding. I think years ago, I was deciding a motion to dismiss. Now, are we going to move into summary judgment with discovery on facts? And what if those facts show that the stipulation's just not right?
I don't know that I fully understand the question just because it's hard for me to dream up the type of discovery that would establish conclusively that Equity Prime Mortgage is a public figure. But what I would say to help frame the issues, and I think this ties into the damages point that we're dealing with. Right now, this is more akin to a motion to dismiss. It's closer to that than a motion for summary judgment because the question is whether our case minimally has merit. And you'll be able to revisit the question of presumed damages and punitive damages at summary judgment and at trial. And there's no requirement, and in fact, you shouldn't, and I'll get into this in a moment, wade into whether we have made the requisite showing for those two issues. I think if at a later time the court decides that it makes sense for whatever reason for Equity Prime Mortgage to be considered a public figure, then that's something that's taken up at a later time. But it should not be used to prop up this otherwise doomed motion under the anti-SLAPP statute. That's the key point is in the context of this anti-SLAPP statute, they said, hey, they're a private figure. They're a private figure in the context of this anti-SLAPP. So they should not be able to reverse and say, wait, no, they're not. And I think it is in consideration of the same anti-SLAPP motion. So if there's future litigation on that, once we're past this phase, that's a separate question. But it's really hard for me to wrap my mind around how they can be allowed to benefit from their stipulation and avoid discovery, and then turn around and find a separate benefit based on the appellate court's decision that granted us limited discovery under a second statute.
Okay. Thank you.
So I think that addresses most of the stipulation and private figure issue. But the other thing I said at the beginning of my comments was that I was troubled, and that's because the flow chart presented to you. One second, I'm going to share my screen. Can you see that?
Yes.
So here we are, public figure. The question here is plaintiff a public or private figure? If they're a private figure, the question is the statement about a matter of public concern? And the answer is no. The private malice standard applies. If the answer is yes, the question is the plaintiff seeking presumed or punitive damages? Okay, so I want to key into that issue. Now, we are, for a portion of our case, seeking presumed or punitive damages. But the question for you isn't whether all of our damages theories, whether all of our damages theories are viable at this stage. The question for you is whether any of our damages theories are viable at this stage. Here, we are seeking special damages. We're seeking actual damages for the harm that EPM suffered. So since that's the case and that's been stipulated, you don't need to delve into any other aspect of the damages question because as a matter of law, we have pled a claim and have facts supporting that claim that support a damages case. And here, I think it's very important to understand that this is not summary judgment. There's no motion for summary judgment on the punitive damages issue or the presumed damages issue. And we'll have the opportunity to litigate that later. And what EPM is going to say about the burden at that stage is different from what the burden is at this stage. And I don't want to bore the court with all of those distinctions, but we're borrowing a problem from tomorrow for today in a way that is incredibly unhelpful and will result in an error of law, which is what we're trying to avoid. So with all of that being said, I ask the court, I beg the court to keep separate in its mind the fault element where negligence applies and the privilege element where Oskaway informs us that private malice overcomes that conditional privilege. We don't need to mix those together because that's where so much of the confusion occurs.
Okay. Okay. Thank you, Ms. Watkins. All right, Mr. McDougall, I am concerned and,
Your Honor, before you start, I do have some input, if I may offer it.
go ahead.
Okay, thank you, Your Honor. In speaking about the delay that occurred, and where we're at now, where the court has instructed us to allow depositions on actual malice, I think it's important, and I don't think the lawyers can dispute this. I don't know where it may be in the record. I know it exists in the correspondence between the lawyers. Back in 2021, after this motion was filed, the Green defendants offered to allow depositions to go to the actual malice issue. And that was declined by the plaintiffs at that time. So I think if before they can point their finger at the Green defendants as having delayed all this, they need to look in the mirror and realize that they had that opportunity early on and declined it. That's
Okay.
first. Thank you. I'm sorry.
No, I just said, okay.
Okay. Secondly, Your Honor, I've kind of done my own 5-part analysis. I guess it's the old Fifth Circuit law clerk in me of where we're at. And I will offer it for whatever it's worth. But it seems to me that the tree that we're working on right now starts with, are the Green defendants allowed to assert the public figure defense? If the answer to that is yes, then I think we have to follow EPM 2 and discovery will be limited to actual malice because that is the issue before the court for it to resolve the motion to dismiss. So part 1, public figure, is that allowed? If it is, part 2, then discovery should be limited to actual malice. Part 3, if it's not allowed and therefore we treat EPM as a private figure, then I think the issue of damages is relevant. And if damages, as they have acknowledged, they are seeking presumed damages, then under the authority that I read from the Green defendants, once again, we go back to the issue of actual malice as the standard, and discovery, part 4 of my thing would be discovery would be limited to actual malice. And then part 5 would be if it's not a public figure and they're not seeking presumed damages, which Mr. Watkins just said they were punitive, but if not, then I think the private malice standard applies and we open it up for the for full discovery. That's kind of my 5-part analysis. If you got those 5, and maybe that'll be helpful.
Thank you. I appreciate it.
Yes, Your Honor.
All right, Mr. McDougall, let's close it out, sir, if you don't mind. Again, I'm a trial judge, and I'm obviously, number one, trying to get it right. But I do also say once again that I also have the practicalities of docket management. And this one isn't going well. And I believe that the Court of Appeals is between the lines or maybe right out in the open telling me that some discovery should be had here. What do you think?
I think they told you at a minimum to allow discovery on actual malice. So if we prevail on if we're allowed to assert the public figure defense and the issues that are in front of the court are in the actual malice box, I read the opinion as instructing the court to allow actual malice discovery.
Okay.
Okay. And if you go through the analytical steps that we've all been talking about, can we assert the defense? Are they a public figure? If not, are they seeking presumed punitives? Those you have to walk through all of those. But if you deny the motion in its entirety, then we're in regular discovery. And the last thing I'll say is that Mr. Watkins, excellent lawyer, but But he wants to put the question of presumed and punitive damages for another day. Oskaway says that's a threshold determination in footnote 19. So it's not for another day, it's for today.
All right. All right, I don't need any additional briefs.
Okay.
I thought the estoppel argument was well made. I took notes as best I could. I understood it, I think. I have Mr. Lane if all else fails, and I think I'm good there. I
Okay,
think the thing to do is for the court to make a decision.
All right. You know, we do have something to say about the cases they cited, but which I didn't cover, but you know, we proceed as the court directs.
Then know this. Monday morning, and this is back to practicality, and I can't be clearer than that. This is Friday. On Monday morning, I do start a criminal jury trial, which I anticipate going all week next week. So, oh man, I'm going to hate myself in the morning. But do you want to do other briefs?
I want to do something. We haven't responded in writing to the estoppel arguments, and I would like
Okay.
the opportunity to do that. I did not file a reply because I didn't think I was allowed to.
Let me just put it this way. I'm not making a decision before next Friday.
Okay.
Let me be clearer. I'm not making a decision before 15 and 7 is September 22nd.
Okay. Well, I'll tell the world, then we will file something. I think Mr. Watkins and the plaintiff, they need a chance to be heard. They contend they've not had the proper chance to be heard. If he wants to file something in response, I would welcome that. And in order to accommodate that and move the case along, we will file ours quickly.
Okay.
File what? The motion. Let me finish. The anti-slap motion was filed years ago.
I know.
We have a remand order. There was clarification asked. Are we just throwing papers at the court? I've litigated.
Mr. Watkins, I've said that I am not going to make a decision until a certain time. And anyone who wants to supplement what they have argued today with either the actual citations that they read out or with argument that they felt like, oh my gosh, I wish I'd said that, is free to do so. Anything else?
Not for me,
Okay.
Your Honor.
Your Honor.
All right, then everybody have a great weekend. It is always good to see you. It is always certainly stimulating for the court. And I hope you feel better, and everybody have a nice weekend.
Thank you, Judge.
Your Honor.
Thank you, Your Honor.